All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Welcome, everyone. Court officer, please call the case.
Good morning. Situation in the Republic of Kenya. In the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, case number ICC 0109-0111. And for the record, we are in open session.
Thank you very much. Appearances, please, beginning with the prosecution.
Mr. President, Your Honors, the Office of the Prosecutor is represented today by Mr. James Stewart, Deputy Prosecutor, Anton Steynberg, Senior Trial Lawyer, Cynthia Tai, Trial Lawyer, Ade Omofade, Trial Lawyer, Lucio Garcia, Trial Lawyer, Grace Go, Case Manager. I am Prosecutor Fatou Bensouda.
Thank you very much. And the defense?
Mr. President, Your Honours, good morning. Mr. William Ruto, who sits behind me, is represented by David Hooper of Queen's Counsel, Essa Fal and Shamla Alagendra of Counsel, Miss Lee Laurie, our legal assistant, and at the back, Andrew Mora, Shalini J. Raj, and Grace Sullivan, who are members of our trial support. Your Honours, my name is Karim Khan QC.
Thank you very much.
President and Your Honors, Mr. Sang is present, and his defense team is constituted of myself, Katwa Kigan, Caroline Boisman, Logan Hambrick, Judy Miongi, Philemon Koech, and Joel Bosek. Thank you, madam.
And for the victims?
May it please Mr. President, Your Honors, I am Wilfred Nderitu, counsel for the victims. I am assisted by Mr. Ochlon Narantseksek from the OPCV and my case manager, Ms. Caroline Hatzig. Thank you.
Is there any representative from the registrar? I say, Mr. Deputy Registrar at the back, if you can also introduce your team.
Monsieur le Président, Madame, Monsieur les juges, au banc du greffe, nous avons aujourd'hui mon collègue Peter Van Verbeek, juriste coordinateur à la direction du service de la Cour, et moi-même Didier Préra, greffier adjoint, représentant le greffier.
Thank you very much. We are convened to commence the trial of Mr. William Samuel Ruto and Mr. Joshua Arap Sang. As a preliminary matter, it may be of some assistance to take a moment to review briefly some of the milestones along the procedural road we have traveled to arrive at the phase of the case that begins today. The origins of this case are the 2007 elections in Kenya. In the aftermath, the prosecutor, on the 26th of November 2009, requested authorization from the pretrial chamber to conduct investigations into what is known in ICC terminology as the situation in Kenya. On the 31st of March 2010, the pretrial chamber granted the prosecutor the authorization to conduct the investigations as requested. As part of the unfolding proceedings, the prosecutor requested the pretrial chamber to issue summonses to 3 individuals, requiring them to appear before the court. The individuals are William Samuel Ruto, Henry Kiprono Kosgei, and Joshua Arap Sang in this case. We are not talking about what happened in the companion case. By a majority of the pretrial chamber, a decision of the was rendered on the 8th of March 2011, issuing the summonses to appear. Summonses to appear, or a summons to appear, is a judicial mechanism that aims to secure the attendance of accused persons before a criminal court without the more aggressive method of arrest warrant and detention to secure such an appearance. On the 7th of April 2011, the 3 persons mentioned earlier as the subject of the summonses to appear indeed voluntarily appeared before the court in their initial appearance. The accused in this case remain under the regime of the summonses to appear and have always appeared whenever required to do so for purposes of the proceedings thus far, and on some occasions even appearing of their own accord without being required by the court to appear. At the stage before the commencement of trial, the Rome Statute does not require accused persons to always appear before proceedings unless directed by a chamber to do so. On the 31st of March 2011, the government of Kenya launched a challenge before the pretrial chamber, arguing that the case was not admissible before this court. The legal basis for such challenges is Article 19, read together with Article 17 of the Rome Statute. According to those provisions, a case is not admissible to be tried at the ICC if, among other reasons, a state with sovereign jurisdiction over the crime is investigating or has investigated or is prosecuting or has prosecuted the case. But admissibility is not precluded where the state in question is unwilling or unable genuinely to carry out or genuinely to have carried out the concerned investigation or prosecution. In its admissibility challenge, the government of Kenya argued that it could fulfill its primary responsibility as a state party to the Rome Statute by exercising criminal jurisdiction over those responsible for the international crimes allegedly committed in the present case. In other words, the government argument was that it was willing and able to investigate and prosecute the case. On the 30th of May 2011, the pretrial chamber rendered its decision on the admissibility challenge. It dismissed the challenge. In dismissing the challenge, the pretrial chamber found that the evidence presented before it did not demonstrate that the government was, quote, taking concrete steps showing ongoing investigations against the 3 suspects in the case, unquote. Therefore, the pretrial chamber held that the case was not, quote, being investigated or prosecuted, unquote, within the meaning of relevant provisions of the Rome Statute. Furthermore, the pretrial chamber held that any investigations anticipated by the government did not, quote, cover the same persons subject to the court's proceedings, unquote. On the 30th of August 2011, the appeals chamber confirmed the decision of the pretrial chamber in the appeal of the pretrial chamber's decision dismissing the admissibility challenge. From the 1st to the 8th of September 2011, the pre-trial chamber held proceedings in order to consider whether or not to confirm the charges that the prosecutor had drawn up against the three men that I mentioned earlier as the subject of the summonses to appear. On the 23rd of January 2012, the pre-trial chamber issued its decision on the confirmation of charges. In that decision, the pre-trial chamber, by a majority, confirmed the charges against two of the three men in the persons of Mr. Ruto and Mr. Sang, finding that there were substantial grounds in the evidence presented before the pre-trial chamber to believe that the two men are criminally responsible for the crimes charged. It is important to stress that this does not mean that the two men have been found guilty as charged. The pre-trial chamber's confirmation decision of charges is only a manner of saying that the case of the two men must proceed to trial for a trial chamber to conduct proper judicial inquiry with greater depth, at the end of which findings of guilty or not guilty may be entered. As regards the third man, Mr. Kosgei, the pre-trial chamber dismissed all the charges. The third judge in the pre-trial chamber dissented. He found that none of the charges should have been confirmed against any of the three men because the events charged as crimes do not rise to the level that deserve judicial inquiry before this court. According to him, those were events best left to national prosecuting authorities to deal with. The charges having now been confirmed against Mr. Ruto and Mr. Sang by a majority decision of the pre-trial chamber, their case was transferred to trial chamber 5, as it used to be, for purposes of preparing for and conducting the trial. The preparatory work done by the trial chamber 5 included considering and disposing of a very large number of applications by the parties on various matters. The applications included one by the counsel for Mr. Ruto requesting that he be excused from continuous presence during his trial. It is to be noted in that regard that during the investigation of this case against him, right through the confirmation of the charges against him, up to the transfer of his case to the trial chamber for trial, and the trial chamber's setting of an initial date for the trial, Mr. Ruto was a private citizen of Kenya. But earlier this year, he was elected the Deputy President of Kenya. In consequence, his counsel brought an application requesting the chamber to excuse him from continual presence at trial in order that he may continue to perform his constitutional functions as Deputy President while his trial continued at the ICC uninterrupted. The chamber considered that application and granted it conditionally by a majority decision, setting out a number of proceedings that he must attend in any event and reserving in the chamber a residual power to direct Mr. Ruto's attendance at other times. In the decision, the majority reasoned that the Rome Statute read as a whole and in its realistic context allowed the chamber sufficient discretion to grant an excusal on an exceptional basis to persons who have important functions of an extraordinary dimension to perform, and the chamber reasoned the functions, not merely the status of the Deputy President of a country, would qualify the holder for such an excusal. Implicit in the decision is the need to avoid the trial being slowed down or bogged down by collateral pressures upon the trial generated by any tension between the legitimate demands and other circumstances of his office on the one hand, and on the other hand, the perfectly justified requirements of international law so clearly reflected in the Rome Statute that every individual, regardless of office, must submit to the imperatives of accountability for their conduct, such as those in the nature of the crimes described in the Rome Statute. In the Chamber's view, those imperatives of accountability recommended a trial that proceeded in full celerity without interruption as commanding the greater concern of the foreseeable circumstances of the sort of tension mentioned above. But in granting the excusal, the Chamber made sure to stress that the excusal that was permitted Mr. Ruto was, quote, strictly for purposes of accommodating the demanding functions of his office as Deputy Head of State of Kenya, and not merely to gratify the dignity of his own occupation of that office, unquote. The prosecution has appealed against the Chamber's decision. The appeal remains pending. In the meantime, the prosecution has also requested the appeals chamber to suspend the operation of the Chamber's decision granting the excusal, pending the appeals chamber's decision on the merit of the appeal. That suspension was granted. In the result, Mr. Ruto will have to be present throughout his trial, pending the decision of the appeals chamber on the merit of the case. And on that note, the record will reflect that Mr. Ruto is present in court today. The date, I pause to say that in any case, was one of the conditions originally indicated by the trial chamber in the excusal decision. The date for the commencement of trial was initially set as the 10th of April, 2013. That date was vacated and set to the 28th of May, 2013. The latter date was again vacated and finally set to the 10th of September 2013, that is today. To persons who are not students of comparative criminal justice systems around the world, it may seem strange, indeed, that the trial date had been set 3 times. But everyone should be reassured that there is nothing at all unusual about that. In some criminal justice systems, this is a very normal occurrence. The idea being that even setting trial dates and adjusting them give the parties a date, a time frame that guides their preparation for trial. It is better to set a trial date and adjust it as needed than to defer setting a trial date at all until all the procedural wrinkles in a case have been ironed out. The latter course would lead to greater delay, some may think, in setting a real trial date, considering that procedural wrinkles in any complex case are always present. We have now finally arrived at the date for the commencement of the trial. We will next read the charges to Mr. Ruto and Mr. Sang, following which I will invite them to enter their pleas. In a moment, I shall call upon the court officer to read a synopsis of the charges section of the charging document. But before I do that, I note that Mr. Ruto and Mr. Sang have each individually filed a declaration of understanding of the charges. In those declarations, Mr. Ruto and Mr. Sang each confirmed that he has read the updated document containing the charges in its entirety and was duly informed in detail of the nature, cause, and content of the charges against him, and in a language he fully understands and speaks. Is that the case, Mr. Khan?
It is, Mr. President.
Thank you. And Mr. Kigenkatwa?
Yes, it is, ma'am.
Thank you very much. That being the case, the court officer will now only need to read the synopsis of the charges against the 2 accused persons in the charges section of the document containing the charges. Court officer, please read the synopsis.
Yes, Mr. President. William Samoei Ruto committed the crimes charged below as an indirect co-perpetrator with others pursuant to Article 25(3)(a) of the statute. Mr. Ruto, together with other key members of the network, together with Joshua Arap Sang, had a common plan, the goal of which was to attack particular parts of the civilian population due to their perceived affiliation with the Party of National Unity, PNU, permanently expelling them from the Rift Valley and to gain power and create a uniform ODM voting bloc. It was carried out through the network's subordinates, supporters, and direct perpetrators. As the anointed leader of the Kalenjin people, Mr. Ruto carried out essential contributions to the common plan. His contributions included: 1. Using his authority in the Rift Valley to mobilize supporters for the network and to implement the common plan. 2. Using anti-PNU rhetoric and preparatory meetings and events to create an atmosphere of anti-PNU sentiment and fear among PNU supporters. 3. Providing direct perpetrators with weapons, food, and other logistical necessities. 4. Financing the network. 5. Coordinating the implementation of the common plan via coordination of logistics. And 6. Providing instructions to subordinates and direct perpetrators on where to obtain instructions. Joshua Arap Sang is criminally responsible for the crimes charged below, pursuant to Article 25(3)(d) of the statute. He intentionally contributed to the commission of the crimes committed by a group of high-ranking members of the network led by William Samoei Ruto, acting with the common purpose of attacking particular parts of the civilian population due to their perceived affiliation with the Party of National Unity, PNU, permanently expelling them from the Rift Valley, and to gain power and create a uniform ODM voting bloc. By virtue of his position with CAS FM as a key broadcaster, Mr. Sang placed his show, Li Ni Emet, at the disposal of the organization. Mr. Sang, first, broadcast propaganda against PNU supporters prior to the attacks. Second, broadcast preparatory meetings and event locations. Third, used his show to advertise the meetings of the organization. Fourth, fanned the violence through the spread of hate messages explicitly revealing desire to expel the Kikuyu. Fifth, broadcast false news regarding alleged murders of Kalenjin people in order to inflame the atmosphere in the days preceding the elections. 6. Call on perpetrators to begin the attacks. And 7. Broadcast instructions during the attacks through the use of coded language in order to direct the physical perpetrators to the areas designated as PNU targets. Count 1, Mr. Ruto. Murder constituting a crime against humanity. Article 7(1)(a) and Article 25(3)(a) of the Rome Statute. William Samoei Ruto committed the crime of murder of civilians in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town as an indirect co-perpetrator in violation of Article 7.1a and 25.3a of the Rome Statute. Count 2, Mr. Ruto. Deportation of forcible transfer of population constituting a crime against humanity. Article 7.1d and Article 25.3a of the Rome Statute. William Samoei Ruto committed the crime of deportation or forcible transfer of population in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town as an indirect co-perpetrator in violation of Article 7.1d and 25.3a of the Rome Statute. Count 3, Mr. Ruto. Persecution as a crime against humanity. Article 7.1h and Article 25.3a of the Rome Statute. William Samoei Ruto committed the crime of persecution with the intent to attack particular parts of the civilian population based on their perceived political affiliation by murdering, deporting, or forcibly transferring members of the said population in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town as an indirect co-perpetrator in violation of Article 7.1h and 25.3a of the Rome Statute. Count 4, Mr. Sang. Murder constituting a crime against humanity. Article 7.1a and Article 25.3d of the Rome Statute. Joshua Arap Sang intentionally contributed to the commission of murder of civilians committed by a group of persons acting with a common purpose in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town in violation of Article 7.1a and 25.3d of the Rome Statute. Count 5, Mr. Sang. Deportation or forcible transfer of a population constituting a crime against humanity. Article 7.1d and Article 25.3d of the Rome Statute. Joshua Arap Sang intentionally contributed to the commission of the crime of deportation or forcible transfer of a population committed by a group of persons acting with a common purpose in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills Town, in violation of Article 7.1d and 25.3d of the Rome Statute. Count 6, Mr. Sang. Persecution as a crime against humanity. Article 7.1h and Article 25.3d of the Rome Statute. Joshua Arap Sang contributed to the commission of the crime of persecution committed by a group of persons acting with a common purpose and with the intent to attack particular parts of the civilian population based on their perceived political affiliation by murdering, deporting, or forcibly transferring members of said population in Turbo Town, the Greater Eldoret area, Uruma, Kimumu, Langas, Yamumbi, and Kiamba, Kapsabet Town, Nandi Hills Town in violation of Articles 7.1h and 25.3d of the Rome Statute. Thank you.
Thank you very much, Court Officer. As noted, the updated document containing the charges is numbered consecutively from counts 1 to 6, counts 1, 2, and 3 applying to Mr. Ruto, and counts 4, 5, and 6 applying to Mr. Sang, the accused will enter their pleas accordingly. Mr. Ruto, please rise to take your plea. William Samuel Ruto, you have been charged in count 1 with murder constituting a crime against humanity under Article 7.1a and Article 25.3a of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
And in count 2, you have been charged with deportation or forcible transfer of population constituting a crime against humanity under Article 7.1d and Article 25.3a of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
Count 3, you have been charged with persecution as a crime against humanity under Article 7.1h and Article 25.3a of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
Thank you very much. You may resume your seat. Mr. Sang, would you please rise? Thank you. Joshua Arap Sang, you have been charged in count 4 with murder constituting a crime against humanity under Article 7.1a and Article 25.3d of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty, Your Honor.
In count 5, you have been charged with deportation or forcible transfer of a population constituting a crime against humanity under Article 7.1d and Article 25.3d of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty, Your Honor.
And in count 6, you have been charged with persecution as a crime against humanity under Article 7.1h and Article 25.3d of the Rome Statute. How do you plead, guilty or not guilty?
Not guilty.
Thank you very much. You may resume your seat. We have come to the end of the plea entry. Now we will turn to the opening statements. Madam Prosecutor, how much time are we looking at?